Good afternoon, everyone. Welcome to this session where we will look at the legal essentials for music teachers. We felt it was really important that classroom, visiting and peripatetic music teachers know their rights in the workplace. My name is Stuart Dark and I'm the head of ISM's legal services. And I'm joined this afternoon by my colleague Neris Owen, who is a senior legal advisor for the ISM. Both Neris and I have backgrounds in employment law, with Neris having worked in the field of employment rights for the past 15 years, including time working with the TUC and various trade unions. I have previously worked as a trade union official for one of the teachers' trade unions following my legal training. We're really pleased that we get the opportunity to speak to you this afternoon and to help you understand some of the essential elements of employment law so that you're aware of some of your rights in the work setting. A bit of background first about the ISM legal team, and ISM members have access to the in-house legal team at the ISM, and we're a highly effective team who give a wide range of advice to members on employment matters, contractual matters, including unpaid fees and copyright issues. All of these matters must arise in the course of a member's career as a musician. As you can imagine, the past 20 months have been incredibly busy. And over the past year, we've dealt with almost 1,600 queries and recovered almost £170,000 for members. For queries which are outside a member's life as a music professional, there is access to a 24-hour helpline, so members can get advice on issues such as housing, consumer issues or family law, and there's also access to a tax helpline. The ISM also has a legal expenses insurance for members covering employment matters, unpaid fees, personal injury, tax audits, legal defence in criminal and certain civil matters, and identity theft. This means that the ISM don't litigate ourselves, but we are able to pass matters to solicitors through this legal expenses insurance. This is a really vital service for members of the ISM. If you're a member and have a query, don't hesitate to contact us via email when you have a problem. We're going to cover quite a lot today, but these are the things which we felt it was vital for members to be aware of with regards to employment law. We've based these based these points on the questions that ISM members have asked us and the situations where we have given advice to our members. We recognise that there are many different situations for music teachers, whether they be classroom music teachers, visiting music teachers and parents. And this can be across different employers or workplaces with different contracts. We know that many visiting music teachers work in more than one school. In an ISM survey, over 2/3 of visiting music teachers said that they had worked across at least 2 schools. Before we move on, there is the ability as we go along to ask questions using the Q&A function. And at the end, Neris and I will have time to answer some of the questions. But as I've said, ISM members can email us if they have any concerns about their situation or need further advice. I'm going to hand over to Neris to take us through the first set of issues.
Okay, well, hi there. Well, I'm going to talk about employment status. I'm going to spend a few minutes focusing on this because it's the issue that actually dominates our inbox in the ISM legal team, and it's worth asking, why is that? And the reason why it dominates our inbox is because it reflects the extremely precarious working conditions that many of our VMT members are facing. What we're actually seeing here, it's the casualisation of the VMT workforce sort of working itself out in legal terms. So why do laws around employment status matter? And the reason why they matter is because they function effectively as a gateway to statutory employment rights. So what are the rights that I'm talking about here? Well, we've got, for example, holiday pay, key rights, protection from discrimination, sexual harassment at work, the right to reasonable adjustments if you're disabled, right to rest breaks, and so on. Now, if you are a genuinely self-employed music teacher, and you're running your own music teaching business and you're contracting with parents, and this is key, you are negotiating your own hourly rate, then you have no statutory employment rights because you're running a business. You're a sole trader, you are not a worker, and you are not an employee. Now, another key point I want to make right at the outset is to just point out that HMRC uses a different test. Now, as far as HMRC is concerned, there are only two categories. You're either employed, in which case you are paying PAYE tax, national insurance, or you're self-employed, in which case you're not. Now, there is no such thing as a worker as far as HMRC is concerned. So I'm talking here about employment status for the purpose of statutory worker rights. And the key point to make here is that you can be legitimately paying your tax on a self-employed basis while at the same time being a worker with statutory employment rights. And that's a huge source of confusion for many of our members. And the next key point I wanted to make was to draw out a bit of information about the Uber case, which you may have seen in the Supreme Court in early 2021. And it's not an exaggeration to see this case as a bit of a sea change in this context. Now, why is that? Well, it's because the Supreme Court used this case to spell out, and this is key, that it cannot be up to employers, bearing in mind that employers craft the documentation, usually with their solicitors, they decide what goes into it. We're talking the contract documentation that's given to you, usually given to you, well, always really given to you on a take it or leave it basis. It cannot be up to those employers to decide who gets to access statutory worker rights by deciding which terms they put into those documents. And so, as a consequence of that case, what the Supreme Court said was that the Employment Tribunal must effectively ignore any employer contract documents when it comes to deciding who gets to access statutory employment rights. And instead, they just have to look at how the relationship works out in practice, in reality, day to day. And to drive this point home, they made an additional point, and they said that if there are any contract terms in your contract that are designed in order to remove access to worker rights, then those contract terms are effectively void. You might as well put a line straight through them because they have no legal effect. Now, we've all seen contract terms like that. They say things like, I promise that I'm a self-employed person. I promise I'm not a worker. I'm not an employee. And sometimes they even go on, they say, if I take a claim in the Employment Tribunal, I will indemnify you against all the losses and costs that you incur as an employer, blah, blah. All those things are now defunct. You can put a line straight through them. So let's come back then, after making those key points, let's come back to the slide. We have our three categories. We've got employee, we've got worker, we've got self-employed. Now, what's the difference between these three categories? Essentially, it comes down to a sort of spectrum of control. We're talking about different levels of contractual freedom. So we start off with those who have the most control, they're subject to the most control, employees, down to the least control, your sole trader, your self-employed musician who is offering your teaching services as a business. So let's put some flesh on that then. So an employee, who's an employee? It's someone who has a contract of employment, whether or not it's written down. Now, in practice, employed VMTs, they usually have a written contract of employment and it usually spells this out. But what makes you an employee? Well, as I said, it's about control. So if you're an employee, your employer is out to give you reasonable instructions. Effectively, they can tell you what to do within reason. And if you don't follow those instructions, you can be disciplined, you can be dismissed. So we're talking about things like working hours, activities, you're writing reports, you're going to parents' evenings, you're doing training, so on, when you take the holidays. Those are the sorts of factors that make you into an employee. But another important one is that if you're employed, your employer can within reason, they can have contract terms that dictate what you do when you're not teaching. In relation to the pupils, they can have terms that say, you can't teach our pupils on a Saturday or outside school. We've all seen them, or you can't teach our pupils, 6 months after the end of this contract and so on. Now, irrespective of the label that an organisation puts on your contract, if you've got terms like that in it, odds are you're likely to be an employee, because there you are, you're being controlled by the organisation. You're definitely not self-employed. Now, why does all this matter? Well, basically because employees have better job security than workers and self-employed people. They have, and Stuart will come on to some of those, but they have other important rights. They have better parental rights. They have the right to request flexible working and so on. But I'm talking now, I'm working through these categories. So let's think about workers. So who's a worker? Well, there's somewhere between an employee and a self-employed person. This is not necessarily straightforward. It's going to depend each time on the facts. But here's the key thing. Why does it matter? Well, it matters because you don't get job security as a worker. You can't claim unfair dismissal, you can't claim redundancy pay and so on. But while you are working, you get to access these key statutory rights. As I said, holiday pay, protection from discrimination, and so on. So let's assume you have a contract document that says you are self-employed. That's what it says. And you come to us as an ISM member and we have a look at it and we talk through what's actually happening day to day, because that's what matters. And these then are some of the indicators that are likely to point you towards worker status. Okay, so the first one I think that's key is that the school, and this happens all the time, the school is setting or dictating your hourly rate. Okay, you're billing the parents, you're issuing the invoices, but you don't have any say over how much you charge. Now, that is a pretty strong indicator that you're actually a worker, that for the purposes of statutory employment rights, you're not a self-employed person. Now, there's an employment tribunal case on this, a first instance case. That means it's not binding, but it's very interesting from our perspective because it involved a VMT and the basis on which you were very similar to these sorts of arrangements. And the case is Scott against Chigwell School. Now, Mrs. Scott, she was invoicing the parents, but the school was determining her hourly rate on an annual basis. And that was one of a number of factors that led her to be decided to be the tribunal decided she was a worker. She was not a genuinely self-employed person. So that's one. Another one, you see the school promoting your services as our VMTs. It might be on the website and prospectus. Basically, they're selling your services as someone who works for them. Another one, you might be integrated into the music department, and the school controls how you work day to day. Now, as I say, these are all things you have to take in the round. No one will be determinative, but they're all significant. And the final one is that you have to teach your lessons yourself. You can't send someone else to teach your lessons for you, say because you've got a professional music engagement that you need to do, unless you've got the school's approval. Now, I could say a lot more about this particular one, but I'm not going to because it's too complicated. But very broadly speaking, what it comes down to asking is, if you kind of look holistically at the entire relationship and you ask, who am I really working for in this relationship? Who am I really working for? Am I working for the school? Am I working for the parents? Now, it's more complicated than that. That's a fairly good starting point. And that brings me to the final category, which is the genuinely self-employed. Now, we have a lot of genuinely self-employed VMTs in the membership, including genuinely self-employed VMTs who are based in schools. However, it has to be said that in the legal team, we do see too many examples of contract documents that have been designed to look as if you're self-employed, when really, if you examine the relationship, you scratch the surface, it starts to look more like a worker relationship and sometimes even an employee. And that can be very significant when you're looking at, for example, if you want to exercise the duty to make reasonable adjustments if you're a disabled person, for example. Anyway, so now I'm going to go over to Stuart so he can talk about contracts and terms and conditions.
Thanks, Neris. We're going to build on some of the points that Neris has made in this next slide. But like any contract, an employment contract, a worker contract, or self-employed contracts can be written down or they can be made verbally. But any contract that we make will have both express terms, and then contracts of employment specifically have certain implied terms as well. So express terms would include things like how much you're going to get paid, your hours of work, your holiday pay entitlement, how much warning or notice you or your employer has to give you if you're going to bring the employment or the contract to an end. In an employment setting, you might also find express terms in the job adverts, the written statement of particulars, more on that in a little while, any letters your employer has sent to you, or even an office manual or a staff handbook. Now, if you don't have all the relevant documents, ask for them. Make sure as well that you keep any documents given to you by your employer. And if it's a verbal contract, if there's nothing written down, then try and create a paper trail of what's been agreed as well, because that can be helpful if there's a dispute about the terms of a contract. But in addition, every contract, and this is particularly contracts of employment, have general implied terms for employees and employers. So this is if you're an employee. And there are three real implied duties. And the first one is a duty of trust. So for example, if you lied when you said you were sick to get time off work, you'll have broken an implied contractual term of trust. Secondly, there's a duty of care between the employer and the employee, and by the employee to other employees as well. For example, your employer should provide you a safe working environment, and you should use equipment safely. Lastly, there's also a duty to obey any reasonable instruction given by your employer. Now, there's no legal definition of what's reasonable here, but an example I would give is it wouldn't be reasonable to tell you to do something illegal. Now, you may also hear about terms being implied by custom and practice. Now, these might be occasions when something has been done for a certain way for a period of time, or there are certain industry recognized terms and conditions. But you have to know that you can only have terms implied by custom and practice when there is no express term dealing with the issue. So if you've got a 0 hours contract, then you can't say something like, well, it's custom and practice to have a certain number of hours. Now, workers will still have a contract, but it won't be a contract of employment. And any worker contract will set out the terms and conditions and the obligations of the parties. And even if you're a self-employed music teacher, you will still have contracts with those that you're teaching or their parents, or possibly from the school where you're teaching as well. An important right to note here as well, and this goes to written statement of particulars, is that employees and workers have a right to a written statement of particulars. So that's something that has to be written down and come from the employer. And this is a day one right, meaning that you get it from the very first day of your employment. Now, it can be divided up into two. You have a principal statement, which must be given to you on your first day of employment, and then a wider statement, which has to be given within 2 months of starting work. Now, the principal statement must include things like who you work for, your job title and start date. If you're an employee, it must include when your continuous service started. It has to say how much and how often you will get paid, the hours and days of work, and if and how they may vary, your holiday entitlement, and if that includes public holidays, if you're expected to work in different places, how long the job is expected to last, details of any probation period, and also details of any obligatory training that you have to undertake, and whether or not this is paid for by the employer. Now, also, the employer must provide the employer or worker with information about the sick pay and procedures, other paid leave, for example, maternity leave and paternity leave, and any notice periods. Now, employees and workers must then be given the wider written statement within 2 months of the date of starting employment. And then this must include information about the pension and pension schemes, any collective agreements which are in place, any other rights to non-compulsory training provided by the employer, and the disciplinary and grievance procedures. Now, sometimes the written statement will refer to other documents as well, like a staff handbook. So it's important that you obtain and read these documents if they refer to you in your written statement of particulars. Now, these could be on the school or the employer's intranet, or, as I say, in a staff handbook. If you don't get any written particulars, then take advice. If you're an ISM member, then get in contact with us. Turning to 0 hours contracts, we know that a lot of visiting music teachers have 0 hour contracts. In an ISM survey, over 70% of respondents said that they were employed on a 0 hours contract. And what is a 0 hours contract? Well, it's a contract where there are no minimum working hours and where you do not have to take any work that is offered. So hours will vary from term to term, depending maybe on something like pupil numbers, or they might even vary, they could vary from week to week. Now, under a 0 hours contract, you still could have rights as statutory employment rights as either an employee or a worker. Now, those could be the rights to holiday pay, which we'll come on to, or if you're an employee, the right to redundancy pay or to not to be unfairly dismissed. But remember, even if you're an employee, that there are qualifying periods for these rights. So unfair dismissal, you have to be employed for 2 years, and to get redundancy pay, you have to get 2 years. Also, with 0 hours contracts, employers can't stop you working for somebody else. They can't put into contracts what's known as an exclusivity clause. Similarly, they can't treat you any differently because you do work for another employer. Often as well, we get asked the question of whether not working in a particular week or even during, say, school holiday times breaks continuity of employment and breaks service. Now, it's not necessarily, service is not necessarily broken, as it's well recognised that when academic work stops regularly, that there is no break in employment there. So school holidays will count if you're an employee to your continuous employment. Now, guidance from government says that employers should plan ahead when offering hours on 0 hour contracts and not cancel hours with little or late notice. There was talk of reform in this area and potentially legislation, but no employment bill has been forthcoming from the government. We know that it's a potential problem where lessons are cancelled at the last minute, or if there's something like a school trip on that particular day. Now, you may be employed in a maintained school, an academy school, or in an independent school. And so I just wanted to touch on some of the main terms and conditions and things to look out for here as well. Now, if you're working in a maintained school, then terms and conditions will be either in the School Teachers Pay and Conditions document in England, the School Teachers Pay and Conditions Wales document, if you work in Wales, or the Scottish Negotiating Committee for Teachers Handbook, if you work in Scotland. Northern Ireland's slightly more complicated. There's a whole range of documents, but you might also hear about the Burgundy Book in England and Wales. Now, these document hours of work. So in England and Wales, school teachers can be directed for 1,265 hours over 195 days. Scotland is slightly different in that it's 35 hours per week over 195 days. But it's interesting to note as well, colleagues, that the SNCT handbook has additional provisions which cover working time for music instructors. So there's specific mention of music teachers there. I'd always say look out for directed time and what is and is not included in that. So parents' evenings, after school meetings, but what's included in your calculation, especially maybe if you work for a music service as well, or a music hub. Now, these documents also contain contractual sick pay, which goes over and above what is in the statutory sick pay provisions, and also look out for enhanced maternity pay as well, although these have qualifying periods. If you work in an independent school, then check the contract or your written statement of particulars about things like hours of work. Ask questions like, will you be paid for parents' evenings? What are the sick pay arrangements? Is there any scope for negotiating the hourly rate, or is it, as Neris says, is it a take it or leave it situation? But be aware of what you're signing and therefore agreeing to. And if necessary, take advice on what the contractual terms mean. Once you sign a contract, then you'll be bound by the terms that contain within it. Okay, I'm going to turn to Neris now to take us through some of the information about holiday pay.
Okay, well, obviously this is an area, as Deborah mentioned at the right at the very start of this conference, this is an area where we've been very active recently. I'm going to come on to that in a minute, but I'm going to start by making the core point, which is to say that all workers, that's all workers, have an annual statutory entitlement to 5.6 weeks of paid holiday every year. Now that is a universal right under the working time regulations. But notice, coming back to the employment status issues I was raising before, only workers, so that includes employees and agency workers. Who doesn't it include? Well, it doesn't include the genuinely self-employed. So coming back to this then, annual holiday pay, 5.6 weeks of annual holiday pay for all workers each year. So how do you work it out? Well, first, obviously, you need to work out what is a week's pay. And second, you multiply that figure by 5.6, and that produces your 5.6 weeks of annual holiday pay. Now, we say in the ISM, we say that's very simple. That is what the law requires. And the fact that some employees and workers who have a permanent contract are only contracted to work during term time is neither here nor there. And that is what the Brazell against Harper Trust case is all about. So this is a case that the ISM has been supporting, as Deborah mentioned, for the last 8 years. Case brought by our member, Mrs. Leslie Brazell, against the Harper Trust, and that's a group that operates a collection of independent schools in Bedford. Reached the Supreme Court in November of this year. We're hoping for a result in early to mid 2022. Now, what's it about? Well, over many years, a lot of schools have not been calculating their holiday pay in the way that I've just described. Instead, what they've been doing is they've been prorating, they've been reducing VMT holiday pay in order to take into account the fact that although VMTs have a permanent contract covering the entire year, they're only contracted to teach lessons in term time. Now, why? Why are they doing this? Well, they're doing this because they're basing their approach on old ACAS guidance, which was designed for casual workers. Now, this guidance was withdrawn in 2019 as a consequence of Mrs. Brazell's case. But anyway, we would say, and we've always said, VMTs and posts who have a permanent contract, they're not casual workers. So actually, the guidance never was appropriate. But anyway, it's not in place anymore. It's been withdrawn, but it's sort of still got a bit of a ghostly presence because the ACAS guidance is the source of the 12.07% figure that appears in many of our members' contracts in relation to how holiday pay is calculated. So what schools do is they add up the wages that you earn over the course of the term, and then they add 12.07% of those wages on top, and they call it holiday pay. Now, there is nothing in the working time regulations that allows employers to do this, and it results in a shortfall for our members, and that is why we've been supporting our member to the Supreme Court in this case, using the ISM's legal expenses insurance. So then the next question in relation to holiday pay, because holiday pay, unfortunately, is quite sort of multifaceted, but the next question is, okay, how do you work out a week's pay? And it's relatively straightforward, actually, because a week's pay is your normal pay. It's your normal pay averaged out across the year. But crucially, you have to leave out any weeks when you're not working. So in that case, that means obviously you leave out the school holidays because you're not working, and any weeks when you're off sick and you're getting less than your normal wages because you're off sick, SSP, say. So basically, it's a week's pay will be what you normally get paid per week during term time, expressed as an average. But there's another question which is important, very important for our members, which is what pay actually counts for this purpose. And in order to work out a week's pay, this is important. You need to include any regular, that's what the law requires, any regular paid work on top of your normal teaching. So that's to say any regular pay commitments that you do, like a paid ensemble, say, paid training, paid orchestra practice, anything you normally do, anything that's including your normal pay on top of your hourly pay for teaching, and that gets included in the average to work out your holiday pay. Any pay for anything exceptional, anything one-off, like a one-off festival, say, that's excluded, but anything regular should be included. Now, another key point to make about holiday pay is about transparency, because transparency is key here. Now, how do you find out what your holiday pay rights are where you work? And as Stuart said, there's the written statement of employment particulars that has to be included in there. Also, if you get paid, your holiday pay alongside your hourly rate should be on your pay slip. Now, employers, they're allowed to pay holiday pay alongside your contractual hourly pay, but it has to be clear. It has to be clear from the information that's given to you. So you've got your pay slip, your written statement, you maybe have a holiday procedure, whatever it is. It has to be clear, and you have to be able to work out, based on the information the employer's given you, what is your basic hourly pay And what is your holiday pay on top? How has that holiday pay been worked out? And it's the employer's job to spell that out to you. And clearly they need to be paying the correct sum, which brings us back to the Brazil case. So if you've got any problems in relation to your holiday pay and you're an ISM member, send us an email, and we can come back to you and try and help you out. Now, I've only skimmed the surface in relation to this, but we've recently recorded a podcast on this with a bit more detail, so that'll be out quite soon, hopefully. So you'll be able to look to that for a little bit more detail, and there'll be an opportunity for questions too. So I'm going to move over now to Stuart, who's going to talk about pensions.
We felt it was, Nelson and I felt it was important to give a quick overview of pensions as in this presentation, as pensions form part of your total remuneration package. And just a point to make at the outset, we can't give, and the ISM can't give financial advice, but we can run through some of the points. All employers must provide a workplace pension scheme. In the slide there, I set out circumstances where they must enrol you in that pension scheme. That's called auto-enrolment. I want to flag up, though, that this is a right for employees and workers, but it's not available to self-employed music teachers. So if you're genuinely self-employed, then these rights don't kick in. If you do meet the criteria that are set out there, then your employer must write to you when you've been automatically enrolled into their workplace pension scheme. So you will know. Now, you can choose to opt out of that pension scheme, but you can't be encouraged to opt out. Now, even if you don't meet these criteria, then the employer must allow you to join the pension scheme which they operate if you want to join it. It is good to note here, though, or you must note here, though, colleagues, that your employer doesn't have to contribute to your pension. So normally you put something into your pension and the employer does, but the employer doesn't have to contribute if you earn less than £520 a month. Now, teachers in state-funded schools will either be in the Teachers' Pension Scheme in England and Wales, the Scottish Teachers' Superannuation Scheme or Scottish Teachers' Pension Scheme 2015 in Scotland, or the Northern Ireland Teachers' Pension Scheme in Northern Ireland. Now, all of these are defined benefit schemes, and they're based now on career average earnings. They all used to be final salary schemes, but that was changed in 2012. And what a defined benefit scheme means is that they're not based on what you put in, they're not based on a pension pot, but they're based on your salary. Now, independent schools can join these pension schemes, but if they're not part of the public sector pension schemes, then they must have their own. Now, they will be defined contribution schemes. I've mentioned one in the slide called Aptis, which is run specifically for independent schools by Aviva. And these schemes with defined contribution schemes, what that means is that the amount of your pension will be based on the size of your pension pot. That is what you and your employer have put in, and then any changes due to investment. Now, so obviously the value could go up or could go down. Now, some independent schools and indeed music hubs and music services have been members of the public sector pension schemes, but some independent schools are now withdrawing from TPS in England because of the increased employer contributions that came in a couple of years ago. It went from just over 16% the employers were paying in to just over 23%. If you work at an independent school and which is seeking to withdraw from TPS and you're an ISM member, then get in contact with us. And I just wanted to flag up, there was a change from August of this year that allows independent schools to stop new employees or workers being members of TPS, but keep current members of staff as members. Now, in the past, in independent schools, if an independent school was in TPS, then every teacher had to be in TPS. But that's changed now under what's known as phased withdrawal. So as I said, we have to be careful. We can't give you financial advice as this is a regulated activity. However, as a starting point, you can access various free resources provided by government on pensions, and moneyhelper.org.uk is a good place to start. We also wanted just to touch on redundancies and TUPE as well. And I have to say at the outset that these two issues only affect those who are deemed to be employees. These don't apply to workers or self-employed contractors. Example of redundancy situations could be, for example, a school closing, completely closing, and that happens both in the maintained sector and in the independent sector. Or it could be reducing the number of music teachers in a school. And we've heard about that in some of the other sessions. And that could be either curriculum driven, with schools saying, well, we're not going to teach music in the same way, if indeed at all, or a fall in pupil numbers. Now, when you get a redundancy situation, there may be collective or individual consultation, and this will look at ways of minimising or reducing the number of redundancies or finding alternatives to redundancies. And if you're told that there are redundancies and you're a member, then get in touch with us because we can help you through that process. In order to qualify for redundancy pay, as I say, you have to be an employee and you have to have worked for that employer for at least 2 years. Now, the redundancy pay calculation is based on length of service and wages, but it can be capped. Now, it's a two-part calculation based on length of service. Up to a maximum of 20 years service is counted and your age. So for each year of service below 22, you get 0.5 weeks for each year. For each year of service between 22 and 40, you get 1 week for each year. And above 41, you get a week and a half for each completed year of service. That calculation, up to a maximum of 30 weeks, is then multiplied by your weekly pay. Now, there is a weekly statutory cap on redundancy pay on weekly pay, and that's currently £544 per week. Now, if you earn less than that, because you're part-time, then you will get that multiplied by your length of service calculation. If you earn more than that, it could either be capped, but you could get more, but only if there's a contractual right to an enhanced redundancy payment. So it might be based on your actual salary, or alternatively, if your employer agrees to enhance the redundancy payment. So don't expect a big payout if you're being made redundant. There's a really good government statutory redundancy pay calculator. If you go on gov.uk and search for calculate redundancy pay, you'll find that, and it's in the resources that I know have been linked to for today's conference. Also, just to cover TUPE as well, that's the Transfer of Undertakings Protection of Employment Regulations. Now, examples of this would be when maintained schools become academies, that's a TUPE transfer. Or, for example, an independent school merging or being taken over with the employer changing. And that's the key here. The employer changing is important. You should be told if it's happening. You should know it's going on. Get in touch with us again. If you're an ISM member, we can help you with the consultation process that has to be undertaken. But the regulations, in essence, protect terms and conditions of employees. Whatever your terms and conditions are before the transfer have to be followed by the new employer. And that includes things like pay and continuity of service. The new employer can't change an employee's terms and conditions because of the transfer. However, they can change terms and conditions if the reason is economic, technical, or organisational reason involving changes in the workforce or workplace. Of course, employers can improve employees' terms and conditions. For example, they might want to increase pay so it's the same for everybody. But remember that any contractual change has to be agreed. So if they do want to, rare chances maybe that they want to increase your pay, you would have to agree to that in order for the contractual change to take place. Now, you can object to a transfer as well if you don't want to work for the new employer. You don't have to give notice. You simply tell your current employer or the new employer before the transfer happens, and then your employment ends at the time of transfer. This is the same as resigning, so you won't normally be able to claim unfair dismissal and you won't be entitled to redundancy pay. As I say, members should contact us if that's happening. And my advice to people going through the process is always to make sure that your contractual position is sorted out before any transfer takes place. Make sure that any documentation in your personnel file is accurate, as sometimes it can be more difficult to sort things out after a transfer has taken place. Okay, I'm going to ask Neris to take us through the Equality Act.
Okay, then, well, I'm just going to draw out some of the key features of the Equality Act very briefly, and I'm going to try and explain how we use those in the legal team to try and underpin the advice that we give to members. And I want to start by emphasising that actually, in my view, the Equality Act is an exceptionally powerful piece of legislation. We all know that there are loads of practical barriers to bringing employment tribunal claims in. It's all kinds of reasons why it's difficult to bring a claim for discrimination, even if you are underpinned by insurance. Nevertheless, it is also fair to say that no organisation, no school wants to be legitimately called out for engaging in discrimination, for example, failing to support a disabled or a pregnant staff member. And the good thing about the Equality Act is it sets exceptionally clear standards for good behaviour by employers, and it helps subject associations like ours to call out unacceptable behaviour when we see it. Now, I'm talking here about the work section of the Equality Act, but we know, obviously, that the Equality Act has stuff to say too about, say, pupils in a school or a disabled person trying to access a concert venue, say, but I'm talking about work. So going back to work, what does the Equality Act do? Well, it makes it unlawful to treat someone worse at work for a reason that's linked to one of the protected characteristics. Now, they're listed on the slide. I'm not going to list them. Most people are familiar with them. But what I want to emphasise here is just to point out now who is protected, because this is important. So job applicants are protected, workers, employees, agency workers, but let's look at who is not protected, because again, self-employed people who are genuinely operating an arm's length business, think about genuinely self-employed VMTs, they are not protected here by the work section of the Equality Act. So going back again to my slide about employment status as we started this presentation, and think about what that means in practice when you're thinking about things like the duty to make reasonable adjustments, protection from sexual harassment at work, all these things. So not good, but more positively, let's think about who is liable. This is a powerful aspect of the Act, okay? So the organisation, the school is liable, but also, and this is interesting, any individual who is engaged in discrimination, so we might think about, say, a head of music, that's a member of the Board of Governors, someone in HR, they could be personally responsible too if they have engaged in discrimination themselves. Now, it has to be said, in fact, it has to be emphasised that alleging discrimination is a very serious business. It is not something that you do lightly, but nevertheless, the Act does offer this potential mechanism for holding decision makers to account. And another really important aspect of the Act, which makes it powerful, is that you can only escape liability as an organisation if you can demonstrate that before the discrimination happened, you have already taken all reasonable steps. That's all reasonable steps to stop it happening. So what you have there, in effect, is a proactive duty to promote a zero tolerance approach to discrimination. And this is a key reason why the Act works, why it's an effective piece of legislation. Now, here, obviously, I can't cover it. It's not even a whistle-stop talk, not even at all. I just wanted to pull out some of the key features of the Act. And let me just look at two particular strands then, one positive one and one less positive one. So the duty to make reasonable adjustments, enormously valuable, practical duty, because the law says that if an adjustment is reasonable, then the employer must make it. So if you think about that in the context of COVID, for example, we've been able to use this in the legal department to great effect to help disabled members of staff to say continue working online, teaching online, when schools have started requiring staff to come back and continue with face-to-face teaching. Lots of other examples you could give, but actually there's also an enormous amount of confusion around about what amounts to a disability. And if that's something that you're not sure about, and you remember, come and ask us, come and ask. And the less positive aspect of the Act is is that, as I've mentioned already, really, the failure of the Act to protect genuinely self-employed musicians. So it can't protect them from things like sexual harassment, for example, or indeed any other kind of harassment under the Equality Act. Now, this is a key campaigning issue for the ISM. All I really wanted to say here is just to say that, you know, if that is you, if you're in that sort of situation, if you're suffering from harassment at work and you're a member, get in touch, because there will be things we can do to support you. You know, we might be able to make status-based arguments, as I laid out in the first slide. Anyway, that's all I'm going to say about the Equality Act, and I'm going to turn over now to Stuart, who's going to talk to us about a last topic we're going to cover, which is health and safety.
Thanks, Neris. Yes, last real slide. We felt that we couldn't get away with not mentioning COVID perhaps in this section, but we're going to do it in the context of health and safety in the workplace. So I just wanted to highlight, obviously an employer has duties under the Health and Safety at Work Act 1974, and that's to provide you with a safe and healthy workplace. And it includes things like a safe system, safe place of work, safe system of work, safe equipment, safe and competent people working alongside you. The employers have to carry out risk assessments, taking steps to eliminate and control risks. They have to inform workers fully about potential hazards in the workplace, and they also have to appoint a competent person with responsibility for health and safety. Now, these things also apply to all workers and to the self-employed who are working on their premises as well. So in that context, schools must have a risk assessment that deals with COVID and tries to control or eliminate the risks. Now, there's some guidance out there produced by DfE and in the devolved administrations. And as you heard a little bit earlier as well, ventilation is key to this. And often members tell us, as Deborah said at the very start of the conference, members tell us they work in small and stuffy rooms without adequate ventilation. Now, schools should be looking at these matters and introducing control measures. If that's happening to you in your school, raise the matter with the school management, ask to see the risk assessment, start creating a paper trail about the issues that you're raising, and come and get some advice if you're a member. I thought what Janetta Hurst said in the session about music education in England was interesting as well there, in that good head teachers should be looking at this in the context of their staff as well as the pupils. We've also had questions during the pandemic from pregnant workers as well. And there are specific responsibilities. Neris talked about Equality Act in the last slide, but there are specific responsibilities under health and safety. Where there's a risk to an employee or worker who's a new expectant mother, and that risk can't be avoided, the employer must change the woman's working conditions or hours of work. And if this is not reasonable, or it would fail to remove the risk, the employer must suspend the woman from work as long as necessary on full pay. Now, there should be a separate risk assessment if you're pregnant. And in any event, any existing risk assessment should be reviewed. And the question to ask is, well, can working practices be changed to make it safer? If not, then as I said, you should be suspended on full pay. Now, what could they do? They could look at remote lessons, alternative duties within school, social distancing, larger, more ventilated, well-ventilated rooms. Mark Phillips at the very start said about schools giving over school halls for use for music. Well, those sorts of things should be taken into account with pregnant workers as well. Now, I also wanted to stress that a precautionary approach, a particularly precautionary approach, should be taken to those in the third trimester, as there are potentially more risks associated there as well. And remember that as well, that pregnancy and maternity is a protected characteristic covered by the Equality Act. So if there's a problem, do get in touch, and you're a member, do get in touch with us. So that brings us to the end of our slides, but we're going to talk about any points that you've put in the Q&A while we've been speaking. Just wanted to say again, if you're an ISM member and you've got a question or a matter you need advice on, then contact us using the contact details on the website. If you aren't a member, then feel free to join by going on the website, calling us, or emailing membership@ism.org. Thanks for listening, and we're looking forward to your questions.
Hi, thank you very much indeed, Neris and Stuart. Absolutely fantastic trot across the whole of employment law. Very complicated, I think, employment law. And I speak as somebody who used to practice in the field. It is a complex area. Can I just ask you a question I should absolutely know the answer to, and I can't believe I don't know. Everything that you've just shared with us this afternoon, does it apply equally to all the devolved nations?
Everything I've talked about applies equally to all the devolved nations.
The pensions auto enrolment applies across the UK.
Right.
There's one, I mean, in terms of the Equality, obviously I didn't talk about this, but it is true to say that aspects of the Equality Act are better in the devolved nations, but just not the ones that I've talked about. So there are obviously public sector equality duties that are much more effectively applied in Scotland and in Wales. And thinking about music education more broadly and the obligation to look after all children, for example, you know, I'm sure that's part of the reason why the Scottish approach is as it is, because they have, I think they've effected it as an, I can't remember, it's called the Fairer Scotland duty, and so it enables them to underpin everything they do so much better than, frankly, than we do in England, because it will never be legislated for in England, I don't think.
Okay, I just wanted to clear that up right at the start. So everything we've been talking about, more or less, is right across the whole of the UK. Now, one of the points that's come up in the questions, and certainly when I used to practice, because I did a lot of work for claimants, the big question would be, if I do something, will I be victimised? So if I try and get a better contract, if I assert my rights, am I going to get sacked? Am I going to be treated less favourably, etc.? And I think that's a really tricky area. And there's a kind of a practical aspect and a legal aspect. So if we could take the legal aspect first and then go into the kind of the practical stuff. So Neris, can you just map out for us victimization and how that works?
Sure. Well, if you're thinking about this in the context of your rights under the Equality Act, you have specific protections in relation to victimisation. So, for example, if you were to support somebody's grievance about I don't know, sexual harassment in the workplace, you would be protected if there was then retaliation against you as a consequence of doing that. That's the theory. Similarly, if you try to assert a working time, holiday pay is a good example, because holiday pay is a working time right. If you assert a holiday pay claim, you know, you can't suffer a detriment, which is effectively a form of victimization as a consequence of doing that. Any sort of statutory right, that is the case. But, you know, I don't think you can divorce the legal from the practical. I don't think you can do that, especially when you're talking about zero-hour contract workers, because the big problem is, you know, yes, I cut your hours because, you know, we don't need as many pupils drumming the trombone, or, you know, because Mr. So-and-so has come in and he is, you know, he's able to take trombone lessons and he's a salaried person and you're a VMT. There's always a reason. There's always going to be a reason. And how do you draw out the link between the protected act, you know, supporting the person with the grievance or bringing your holiday claim, whatever it is, and the danger when you get into the territory of 0 hours contracting, the scope to suffer retaliation without being able to explain why I mean, that's not just in our sector, right across. You know, it's a feature. It was one of the reasons why casualisation is so hard to control for, because people have no voice. They have no ability to say, you know, this is happening to what they have. But you know what I mean? They take a great risk. Speaking out is a great risk. I mean, one of my feelings about VMTs actually is that, you know, it's almost 19th century, because you have to be the head of department has to like you. You know, that's what protects you, not your rights. You know, so that's what I think anyway about.
I think you're absolutely right. It does remind me quite a lot of, you know, the concept of hands in Victorian novels, North and South there. You know, they literally would hire hands rather than the person. And with casualisation, that's exactly what we've got. We've got the hiring of hands rather than an individual who has a proper contract of employment. So I've got a question here, which is linked to all of this. If I'm asked to work in an unsuitable room, do I have the right to complain? I often am given teaching rooms in a school that are not fit for purpose.
I would say yes, you have the right to complain, and yes, you have a duty of care for your own health and safety and the health and safety of others. So yes, you have a right to go and raise it with the employer. Now there is legislation that if you are in immediate danger, you can remove yourself from that danger and not suffer a detriment because you removed yourself from that danger. But I hesitate to urge people to use that right. But I would say start creating that paper trail of raising issues with school management, saying it's not appropriate. They shouldn't be in a stuffy room, referencing the guidance that's depending on where the school might be, whether it's produced by the DFE or in one of the devolved administrations, but referencing that to say, no, I'm raising with you the matter about the ventilation in this room. It's not suitable. We need to sort this out. Alternative rooms, suggest alternatives that could be undertaken by the person providing the room.
Can I ask, you made the point there, Stuart, about paperwork. Now, particularly with people on 0-hour contracts, they may not have much paperwork, may they? They may just have bits of payslip, etc. So, Nerys, what's your advice in relation to paperwork? Because it is fundamental to trying to advise somebody, isn't it?
Well, I mean, now, since April 2020, all workers have a right to a written statement of employment particulars from the first day. And we will help.
That does not happen. I mean, I've had emails from members saying, all I've got is the odd payslip.
So they need to come to us. They need to come to us because we will help them enforce that. We do that. You know, that's the point, isn't it, of being linked to a subject association like ours. I entirely take the point that if you've got no power and no voice, you're going to end up, you know, with just a payslip. That's why you belong. You know, that's why you join people. I mean, it's not supposed to be an infomercial, but that's why you join an organisation like ours, isn't it?
Yeah, absolutely. I mean, we came across that quite a lot during the start of furlough, where people who, again, were treated pretty abominably, and all they had to show for a 15-year relationship with a music college was payslips. That's all they had.
And that was as the law was changing as well, because it was April 2020 that it came in for workers. So yeah, I can imagine people not having a lot, but now is the time. I suppose what Nerys is saying is now the time. If you don't have that information, come and talk to us if you remember, and we'll help you assert that right, for want of a better phrase.
So very important that we get all the paperwork in place. Is there a risk, going back to that detriment point? I'm a 0-hours contract worker and I toddle off to my employer and say, I want written terms and conditions. Is there a risk there?
I suppose there's always a risk with anything. I think sometimes if there are the protections that Nerys pointed out with the kind of victimisation, what the law tends to do is the law tends to act after the fact rather than necessarily before the act as well. So that's the point, I suppose, around the precarious nature, almost the piece rate nature of some of the work that the visiting music teachers are doing. That, you know, yes, you get your hourly rate for paying for teaching a pupil, but you don't get any more than that. And then there's so much more to the job other than just teaching the pupils as well. So I suppose that control element by yes, a director of music or something like that, the law can't necessarily stop them, but we'd hope that through us educating our members and supporting our members, they'd have the confidence to say, well, give me this, and then we can support them if something does happen to them, if there is any kind of comeback on them.
So I'm sorry that so much of the questions are really around detriment, which is, I think, the nature of the workforce actually, and the fact that it is so vulnerable. So
doesn't surprise me at all. It doesn't surprise me at all.
So I'm afraid
this is what my point is. You know, it comes down, and we see this all the time. You know, if you've got to be liked, you've got to be liked by the head of music. You know, you have no power. It's dreadful. You know, it is like the 19th century, because it's putting your hand up is a very hard thing to do.
Okay, another detriment question. So if the employer puts me in contact with a solicitor for advice, will my employer find out? So I think, Stuart, if you could just talk through how the legal team actually works. So this kind of question wouldn't actually normally arise. So Stuart. Yes.
So if members contact us, they do so on a confidential basis. We don't then tell an employer that a member may have contacted us in any way. We'll talk to a member and say, okay, this is our advice. This is what we think you might need to do about this. If we're going to write letters, we'll agree the letters beforehand so that the members are aware of it. We communicate with members privately on personal email addresses rather than through school email addresses. That sort of thing, to protect that confidentiality. I mean, if the employer as well has put someone in contact with a solicitor who's not us and not the ISM and not legal advice through the ISM, obviously there are certain duties of client confidentiality there as well that a solicitor would be under, not to tell the employer. But yes, members coming to us, it's on a confidential basis, and we would agree with members when contact would be made with the employer.
I mean, that's a very important point. And if, having had all the advice from the legal team, the member then decides, well, actually, I am feeling too vulnerable to take this further, then that's perfectly fine, isn't it?
That is. We don't do things without members knowing about it, without their consent, without their buy-in. It's their, as you say, Deborah, we're not in the workplace with them. They're in the workplace, and so they have to make those decisions. It's that point about, you know, we give advice. It's up to members sometimes whether they want to follow fully that advice or just want the advice.
So
sometimes just talking through an issue, you know, is so valuable, and well, it does give you an insight, I think, into how difficult things are on the ground. You know, yes, there's no getting away from the fact that it is hard for people to take steps in this kind of world that we are living in.
And I think that's a big difference between 0 hours and, say, having a full contract of employment and working in an office. You're so much more secure, so you shouldn't beat yourself up about this. I've now got a status question. I've got quite a few status questions as well, which you will not be surprised at. This is actually quite a nice question. It's a tricky one. If the school mentions visiting instrumental teachers in its publicity and asks the teachers to agree their fee as a group, are they workers or self-employed?
Well, it's interesting, this thing about asking teachers to agree their fee as a group, because it's something we come across quite often. And in our view, if a school asks a set of self-employed businesses to agree their fee as a group, they're effectively engaging in price fixing, because what they're doing is they're preventing the parent from opting for the cheapest provider. You know, you're not allowed to do that. If you have self-employed people based in your school, it's entirely up to them to decide how much they want to charge. I mean, you know, there's a commercial reality too. Say there's only the pupil premium on offer. Well, that's obviously what they're going to charge. But that doesn't stop it being a commercial arrangement between the two parties. But if you've got a school saying every year the Board of Governors says your VMT, self-employed VMT rate is £30 an hour, that is not right.
Okay, going back to detriment, so it's another detriment question. I'm on a 0-hour contract, and I am concerned that if I ask for better conditions, I will not get more work from my school. Can my employer cut my hours for requesting changes?
No, they can't cut your hours for requesting changes, but you know, if you're a member, I'd much rather you came to talk to us before you did that. Frankly, I'd much rather you made contact, because these are risky steps and there are ways of doing this and there are ways of not doing this. So, you know, that's my view. It depends, doesn't it? It's not as straightforward as that. Get in touch, ask us properly, and then we'll help you. You know, we can help you make the approach in writing properly with the reasons why you're, you know, the improvements are justified based on the sort of work you're doing. You know, make your case as to why your contract should be different.
So another status question: is there an argument for classing all self-employed VMTs as workers due to their contribution to schools and work hours being dictated by room availability? Quite a tricky question.
It is a tricky question. I think, you see, these things, they all depend on the specific facts each time, but I'm not sure that I think there can be an element of control over you as a self-employed VMT operating in a school, and you can still be self-employed, because obviously you have to fit around the hours that the school pupils in their classes. For a start, you know, you have to have DBS check, you have to behave appropriately in the room that you're using. You know, it is possible to be a self-employed VMT operating within a school. So it's a question of, I mean, it's horrible to say it all depends, but it does all depend. You know, when you're talking about control, I'm talking about sort of control of the content of the lessons, performance management of you and the way you deliver them, you know, like, oh, if so-and-so has complained, if things don't get better, you know, you're not going to be allowed to work in this school anymore, that kind of thing, which where you're, you know, that's where you're not being treated as a self-employed business, if you like. But I don't think there's anything wrong with expecting a business to meet certain standards before they're allowed to operate in your school. I mean, for example, DBS is a classic safeguarding training, for example. It's a classic. I don't think there's anything wrong with expecting a self-employed VMT to have undertaken safeguarding training, say. So, but it's, you know, if only it was so simple. It's not simple, but there again, you know, again, it's not an infomercial, but if you want to ask me that question, come and ask me that question as a member with all the details, and we can talk about it.
Absolutely. I mean, so often these things, you have to go through them forensically, particularly when you're looking at status, because one little bit of evidence can point one way and another bit of evidence can point the other way. And that's why you need to pick through it all to understand whether you're looking at an employee or a worker or indeed self-employed. So another question, but this time I think it's COVID. So it's going to go to Stuart. Recently, a parent has delayed payment for a lesson several times due to COVID. What can I do?
I think we probably need a few more details potentially about what they're, I'm kind of guessing potentially through a self-employed, it's a self-employed music teacher, and it's a matter of unpaid fees. And it goes back, I think, probably to contractual points around what does it say in the contract around cancellation, what has already been said, and so if you examine the contractual position, that may well give ideas. I don't think that, and then can there be alternatives as well to situations? But what's provided in the contract, I think, is probably the ultimate thing. If you're employed and it's happening, I doubt that it is in the same way, but pupils might be missing lessons through COVID in schools, and obviously there might be agreements that have been come to place in schools around redoing lessons or at a later date, rather than, I suppose the problem when you're on a 0 hours contract in school is, as I said, it's that kind of late cancellation of lessons that often happens, and we know that happens as well to members, and government guidance talks about as much notice as possible, but that's not always the case. So again, I'll echo what Neris says, you know, if that person's an ISM member, get in touch with us, because I think there's a bit more to look at within what it says in terms and conditions, what it says in the contract.
And of course, it could be a private teacher asking that question, and so the contract in that situation will be all important.
Yeah.
I have got one more question, which is actually quite a tricky one, and I'm going to give it to Neris, and it's something quite different to anything we've been covering. What is your right, if any, if you are under a gagging order about your job ending in a few months, with impact on many other teachers who don't know? So basically, yeah, I know. I thought so. You've got a gagging order,
non-disclosure agreements. Yeah.
And well, that's an odd situation, isn't it? Because normally these sorts of things come about at the end of your employment.
Yes, but it sounds as if there's been an agreement done partway through the employment, and the employee has been told, right, you're not allowed to say anything about this. So I think there's probably a duty of confidentiality kicking around in.
Yeah, I'll be honest, I don't think I've ever come across a gagging order where someone is still in the job, because that would be incredibly hard to imagine how you could keep that secret. I don't know. I mean, typically, confidential gagging orders are what, you know, the issue is what happens when the employment ends, and you agree not to disclose the circumstances around when you left, and then there's a whole question of, well, you can't, you know, not if it's to do with sexual harassment, not if it's to do with some protected disclosure or criminal thing, or, you know, there's all that. But I don't think I've ever come across somebody having a gagging order and remaining in their job.
It may be that the use gagging order isn't quite the right, that's what it says on my feed, but it may be it's something like a more onerous confidentiality clause, saying you're not allowed to talk about your, you know, the fact you're going to be leaving the organisation. And I suspect at that point it's probably a confidentiality undertaking, in which case, while you're an employee, you have to comply with it. You know?
Yes, well, absolutely. Well, I mean, any confidentiality obligation you should always comply with, whether you're still employed or not, you know, except to the extent that you're allowed to go off and talk about, a whistleblowing issue or something like that. And it's especially important if they still owe you money, because you don't want to give them any excuse not to pay you. So yes, absolutely. Keep it a secret. Don't go blabbing to everyone why you left. You know, not a good idea.
Absolutely. Well, they are still coming through, but I've now got questions about IR35s,
oh my goodness.
Which we won't go into because it's 4:27 on a Saturday afternoon. But I just want to say thank you so much to Stuart and Neris, who have been absolutely fantastic. And as you can see, they're really nice and accessible lawyers. They're not scary at all. And they're very, very happy to help you, no matter what the case is, whether it's big or small, or you might feel, do I really need to bother them? Go and talk to them, and they will certainly be able to help you. So thank you both, Stuart and Neris. Thank you.
Thank you.